importance of the issue, but also obviously because Policy Exchange has been at the forefront of the debate on human rights law reform. And my apologies to anyone for the background noise and interference. No doubt it will further trigger debates on free speech and issues around operational independence, but we're certainly determined, and in an even more adverse environment, Policy Exchange made its voice heard in the debate on judicial power, and it's therefore my great pleasure to be able to welcome this star-studded panel today here on this debate here at Policy Exchange. First of all, very warm welcome to Right Honourable Brandon Lewis MP, newly minted Lord Chancellor and Secretary of State for Justice, who has ignored my plea for him to appear in full fig of Lord Chancellor's robes, but nonetheless will be adorning the occasion. I'm not sure whether Lord Chancellors still have robes, or whether they were cut in the exciting coalition austerity cutbacks of early in the last decade. Also, very warm welcome to Richard Ekins, Professor at Oxford University of Constitutional Law, who runs our Judicial Power Project. Very warm welcome to my colleague in the Lords, Lord Faulks, KC, who's been so singular and salient a contributor to this debate in the upper house and beyond, and one of the preeminent silks in the country. And also particularly warm welcome because of his last-minute spontaneity to Simon Murray, most distinguished advocate, lowercase a, because I think you're not called at the Scottish Bar, if I'm correct, only for the Bar of England and Wales. Been a great contributor to our debates at Policy Exchange on these matters, but most importantly for today's purposes has very generously stood in at the last minute for Nikki DaCosta, who is unable to join us owing to illness, and she sends her apologies, and she too is always welcome on our platform. For thank you for your spontaneity and flexibility. There's also, I'm sorry to say, a political cabinet later on to this afternoon, which means that the time that we have with Secretary of State for Justice and Lord Chancellor is curtailed, but I'll ask him to kick off first, and then maybe in slightly unusual fashion throw open for questions from the floor, and then come back to our other panellists to flesh some of the issues which hopefully have teased out then. So, Lord Chancellor, thank you for joining us today. Nice to have a recall to government colours of your happy debates with each other during your period as Secretary of State in Northern Ireland, and earlier as Security and Immigration and indeed Housing Minister. So always the man of the moment. Thank you.
Thank you, Dean. And look, it's a great pleasure to be here with Policy Exchange. I have, as Dean rightly outlined, I've had the honour of talking to people in Policy Exchange events over the years, and everything from local government through my time at the Home Office and as chairman of the party actually, and obviously in Northern Ireland. And now as Lord Chancellor, it's good to have an opportunity to talk to you a bit about what we're looking at and what the plans are as we move forward. And yes, we do still wear robes as Lord Chancellor. As I found out on Thursday, having started off thinking that maybe things have moved on, I found out at my swearing-in ceremony that no, you still wear robes, and my 19-year-old daughter will eventually forgive me for putting on a wig and a pair of tights on Thursday and then putting it on Instagram, which I will be going back to do again tomorrow, because we have the opening of the legal year. So I'll be heading back to London for that before coming back, because I actually do think one of the things that we will focus on, and I'll talk a bit more about this later in the conference week, we have in our country something to be very proud of, which is a world-leading legal profession. Legal services in this country actually are fundamental to everything we do across a wide range of areas. And I think sometimes what some of us might think are occasionally antiquated and a bit odd, these ceremonies and services we do actually are really quite important. I think not only to remind the rest of the world but ourselves about the history of our law and how it has evolved and how it continues to evolve to reflect what we need in society. And that will continue as we go forward, and that's where we are, I think, when we start to look at human rights reform. It was our 2019 manifesto that specifically laid out that we will update the Human Rights Act and administrative law to ensure that there is a proper balance between the rights of individuals, our vital national security and effective government. We need to do that, and we need to ensure that we do that in a way that reflects our wish to reduce the ECHR's influence in our system. whilst making sure we retain our other manifesto commitment that is hugely important, which is to remain a champion of collective security, the rule of law, which obviously I have a job to protect, as well as human rights, free trade, anti-corruption efforts, and a rules-based international system. And we took more action on some of this just this week, particularly with regards to anti-corruption efforts with Putin's regime and those who purport to support it. And there is a range of options for us as we go forward to explore in this area of human rights if we want to govern according to our manifesto pledge and remain absolutely true to what we promised to the people who voted for us in 2019. I think we do need to make sure that we are addressing and dealing with Section 2 of the Human Rights Act, the obligation to take into account Strasbourg Court jurisprudence. We need to give consideration to a tighter approach that limits creativity whilst encouraging our domestic courts to have the ability to diverge from Strasbourg case law more freely, that UK courts have primacy in and for UK law. Now, more widely, when we are interpreting human rights framework in the courts, we should always seek to prioritise protecting the public from convicting offenders during the term of their custodial sentence. That, to me, the protection of the public and looking after victims has to be key and heart to everything that we do in the MOJ. But that also plays into a wider approach, and one that I intend to take as the Justice Secretary, which is focusing on, first and foremost, the safety and comfort of convicted offenders never, ever being put over that of the safety of the public and of protecting victims. Now, there are many changes to the human rights framework that will need to be considered, both by government and wider Parliament. And having been a government member of Parliament during a period where the relationship between Parliament and the courts has been strained from time to time, I know how important it is to make sure that if we want to take forward reform in this area, we get it right, so we deliver the outcome we actually want to achieve. It is important that we ensure that the courts recognise the supremacy in a democratic system of the decisions made by Parliament. That does not conflict with the principle of the independence of the judiciary, which, as Lord Chancellor, I will defend to the absolute hilt. But we do need to be clear that Parliament is sovereign. And if Parliament has expressed a view through legislation, then the courts should always respect that view when implementing the law that has been passed. Now, this is a complex area to get that balance right, and it's one that will require a lot of work in order to make sure that our proposals are fulsome, and it is a principle that we can all support. The need to reduce the court's backlog is also something that has challenged a few Justice Secretaries before me as well. But due to the recent strike action as well as coming out of the COVID pandemic, we've seen that backlog go back up and become more challenging. I want to make sure that during my period of time as Justice Secretary, all possible avenues are being explored and considered. I want to be working with the judiciary, who are equally keen to see this backlog dealt with, to look at what more we can do to get that backlog back down and ensure that we're looking at every opportunity to do that. I intend to put my department to work in exploring what can be done to also ensure that we curb the use of slaps. These are strategic lawsuits against public participation. They are too often used by wealthy individuals to intimidate and silence the critics. And it's not right that money can buy legal impunity in our system. We need to ensure that we have a system here, a system of human rights that doesn't create or give cover for a cancel culture. We need to do everything we can to protect freedom of speech, even when it can be really, really annoying. We can't allow people to claim their human rights are being infringed because they disagree with us. Democracy is about debate. Democracy happens because of debate. Debate means having that opportunity to say what you believe, to make a case for it, to argue for it. We all have a duty to be aware that what we say matters, to be aware that when we speak, we are talking to people and that will have an impact. We need to be free to have that debate and that conversation. We're not asking about, and we're not talking about in this context, protecting terrorists from inciting hatred, which must always be something we have the legal ability to deal with. But we do need to make sure that people in everyday life and in public life can have their debates freely and have those debates openly and properly. And if that means occasionally the odd one of us as a politician gets a bit offended and needs to fight our own corner, That's what democracy is about, and that's worth defending as we look at the human rights and the freedom to do that as we move forward. I'll pause there.
Thank you. So because of the unusual last-minute circumstances, I'm just going to take it in slightly unconventional order and put Lord Chancellor on the spotlight, as it were. We have first tranche of questions. I'm sure there'll be many questions here. Do I see anyone from the floor? Lady there, if you only house rule, you just have to state your name and organisation. No question too outrageous, but that's the issue. Please. Do you need... Sorry. By the way, could everyone hear the Lord Chancellor? Can I also ask, does everyone find it a great nuisance, the background noise? Can I just see whether there are any dissenters to this opinion, so I can make representations?
Is this a request to change the freedom of speech plan?
No, it's just I want to get a flavour of opinion here, so I can make representation on behalf of Madam. Your
Hello,
question.
my name's Grace DaCosta. I'm from Quakers in Britain. I was
From which organisation, sorry?
The Quakers.
Yeah.
I was wondering what was happening with the Bill of Rights bill, whether that will be brought back or whether there'll be other legislation to replace it.
Do you want to answer that?
Yeah, sure. So we are looking at a range of things from what would have been in the Bill of Rights bill, which we're not bringing forward at the moment. What we are looking at is what is the right piece of legislation to bring forward some of the measures that we wanted to deal with. For example, I've just been talking about at the end of my few words there, freedom of speech, strategic lawsuits against public participation, things like that, how we do that, what's the best, speediest way of dealing with that. I know a lot of people, and we as a government are determined to make sure we are dealing with the issues that can help us deal with the issues around illegal immigration. I'm working closely with the Home Secretary to ensure that we can put together legislation that deals with that. So those key tenements we wanted to deal with, we will deal with, but we'll probably do it in different pieces of legislation.
I see there are gentlemen there. Your name.
And I didn't just say that for the benefit of the Home Office Minister in the room, the great Lord Sharp.
Chris McKeon from the Press Association. I just wanted to ask about you mentioned the strike action. Obviously, one of the major complaints from the Criminal Bar Association is about legal aid and money. In the context where we have a Treasury looking to cut funding, will you be pushing to protect and indeed increase funding for legal aid?
Well, we obviously one of the key, or probably the number one acute issue on my desk on coming into office has been dealing with the bar strike. They will be going to ballot next week. I am hopeful that they will I'm confident they'll look at the proposals carefully. I'm hopeful that they will look at them positively and vote, and that we will see an end to the strike. It's a comprehensive package that deals with the issues that need to be dealt with. So look, I'm hopeful we'll deal with that, which will help move things forward, and actually puts the whole structure, particularly for the junior bar, in a very different place in terms of covering off some of the issues and giving payment there for Section 28, which I want to see more of, to deal with RASO cases, so rape and serious sexual assault cases, and also for paperwork and wasted work, which has been an issue I know for the bar for a very long time. The wider issues around legal aid, we're not at the point of having the future legal aid budget looked at yet, but at the moment, as I say, I'm very keen to ensure that we have a judiciary that is able to work. I want to make sure we've got a judiciary and a bar that's able to work in a good environment as well. One of the issues around dealing with the court backlog will also be making sure that all of our courts can function properly. And we are blessed in this country with great teams who work across those courts doing the best they can to keep them functioning, and I want to make sure they've got the support that they need.
I can just ask a question that's just come in on WhatsApp for you, Lord Chancellor, where it's from Rajiv Shah, formerly number 10 Constitutions Pad. He said, does the Lord Chancellor agree that it is important to ensure that our domestic courts cannot gold plate the ECHR and go beyond Strasbourg?
Obviously, first of all, as the Lord Chancellor will reiterate, I do believe absolutely in the independence of the judiciary. So I will respect and protect their independence. But one of the things I said in my opening remarks is I want to make sure that equally our judiciary is clear that of a couple of things. One is that Parliament is sovereign, and if Parliament passes a law, our judiciary are delivering on that and respecting that, but also that in UK law, UK courts have primacy. And if there is a reflection from Strasbourg, it's a matter for the UK courts how they interpret it.
I see quite a lot. Lady at the back there, please, name an organisation if you don't mind.
Hi, Megan Rowland from Tier Fund. My question is to you, is to you, but also to the other panelists, which is, what would you say to those who are concerned that these changes could have, the implications these changes could have for our standing internationally, and also in holding other countries accountable for human rights?
Well, I'll let Dean decide when he's going to come to the others. But look, internationally, I think we are in a very, very strong place. Our legal system is respected around the world. We are number 2 after the US in the world, number 1 in Europe for legal services. I think as we move forward, there's an opportunity for us to grow that sector. It's something I'm very, very interested in, very keen to work on. I mentioned this in my speech at the swearing-in ceremony the other day with crypto and blockchain and things like that. There's big opportunities for us. That is fundamentally, you are right, built on our international reputation as a centre for law and the rule of law. But the rule of law is what recognises the sovereignty of Parliament. So I think it is entirely right that Parliament is sovereign. If Parliament passes law, the judiciary is then the independent judiciary that deals with the decisions made around the law that Parliament's passed. That's how the rule of law develops. So I think it is absolutely in line with our international standing that Parliament's supremacy is there. That is what our democracy is founded on. And I think without that, our democracy suffers.
Thank you. If I could just ask the other speakers just to hold fire for a second, unless anyone particularly wants to intervene at that point. Who else do I see? I see there seem to be quite a lot of hands up. Gentleman there, yes. Thank you. Sorry if you just wait till the microphone comes. And then you after that. Thank you.
Yeah, I think the human rights situation in the UK is quite impressive, I must say. An overview.
Could you speak up a little, just because I'm afraid to impose.
An overview of the current situation is, it seemed to me, because I have an interest in human rights. My name is Israel Okunwai. Speaking as an individual, not representing an organization. So, I think my understanding of the laws as it stand in relation to human rights in the UK is individuals have the opportunity to bring representations in relation to their grievances before the courts, but they will be doing that not against another individual, but against the state or against the local government authorities. All right, so that makes with quite a unique situation.
Can you ask a question?
So
what's your question?
A contribution would be, would you envisage a situation rather than dismantling the current consultations in relation to creating a bill, which I understand Dominic Raab was working on, and so that would have given rights to a human rights bill, and perhaps that would have given opportunity to quite clearly spell out what the each individual's human rights are, and as opposed to the complex system where you have several legislations, the Equality Act, scattered everywhere, and so it would take a lawyer to find what your rights are.
What is your question?
So my question is, would you regenerate that debate, the consultation process, and see if you could come up with a legislation that guarantees the right of an individual to bring an action against another individual in relation to human rights claims as against the state or against the local government authority. So if you have questions...
Excuse me, sorry.
So that's the question.
You've had your say.
All right, brilliant.
Lord Chancellor.
It's a contribution, it's quite
Lord
positive.
Chancellor.
I think I get the point. Look, I think, so as I say, what we're doing is working through all of the issues that were being considered for the Bill of Rights, looking at how we, which of those we take forward and in which way we take them forward through different pieces of legislation, whether it's through Ministry of Justice legislation or potentially through Home Office legislation, etc., over the next period, whether it's this session or the next session. I think at the moment, it always sounds very simple to bring together lots of complicated legislation. I looked at doing a similar thing, and kind of did this with planning law, actually, when I was in what was then DCLG. It is never as simple as it sounds because of the way these things interact. And actually, when you've got limited parliamentary time, using parliamentary time to repeat legislation you've already got but to put it in a different format isn't a good use of parliamentary time. So I have to say I'm not somebody who's going to be proposing to the Prime Minister that while we've got legislation, and I've got legislation I want to look at to do more to help victims and keep society safe, to bring out legislation that basically repeats legislation we've already got in a different format isn't a good use of parliamentary time. But but you never say never to looking at how you can do things better and more efficiently in the future.
Thank you. Gentleman there, please name an organisation.
Thank you. Benjamin Wood. I'm a secondary school teacher of religious studies. The Human Rights Act at the moment, I think Article 2, Protocol 1 says it includes the right to education, but also the right for parents to have their religious and philosophical beliefs respected in the education of their children. Bearing in mind what you just said about free speech, I'm wondering if you can speak to what you see as the value of that. I think there are some within the party who perhaps have more intolerant voices about ensuring that religious studies in schools is objective and plural.
Well, as I say, I fundamentally believe in people's right to offend me. And I appreciate, hopefully, with religious issues, that's not generally how people take things forward. But, I have a lot of sympathy with some of the debates. I remember seeing a piece a few years ago from Rowan Atkinson, actually, that I thought was brilliantly written around the right to be offended. Our society develops and evolves and grows because we have these debates. And there are things we do today that are so different to what happened in the past because either our tolerance has changed in that we are more tolerant of some things, we are less tolerant of others. And that is evolution. That happens through debate. And if you restrict people's ability to debate and you have a cancel culture, then things don't move on. And they become trapped in one person's view of the world, which I think is very, very dangerous. So, there is always there's a duty on all of us in public roles, and obviously teachers particularly have this responsibility with young people to make sure that there's balance and they've got opportunity to understand what the options are. But that's a duty we have as individuals or as professionals to deliver on our professional duty. I think it's right that we keep the freedom of speech right there for people to be able to argue for what they believe in.
Gentleman there. Yes, you. Thank you. Just wait till the microphone comes, especially important in these circumstances. Okay.
Hello there, Ethan Green, Southend West. So we've just
Sorry,
heard...
could you speak up a little?
Of course. So Ethan Green, Southend West. So we've just heard about your belief in the right of being offended. So I was wondering if you'd be looking into the Communications Act, and specifically Section 127, which is currently under a lot of controversy about the fact that it prohibits grossly controversial speech and therefore means that there isn't a legal right to offend.
Shall we take a bunch of questions together and you can do it? So I'm just trying to get a flavour of the room because of the limited time left. Just trying to... Gentleman there, please. Yes.
Hi, Chancellor Rob Bailey from Lancashire. In regard to freedom of speech, you've recently seen the Free Speech Union be defunded by or have their PayPal accounts removed. Do you think that, could you foresee the new legislation giving a positive right to companies, to individuals to challenge that kind of thing in the future rather than have to rely on contract law?
Thank you for those admirably concise questions. Two more. Gentleman there, gentleman there. Thank you. And we'll... Name an organisation, please.
Thank you. My name is Ikechukwu Felix Ozige. I work with Wolverhampton, Royal Wolverhampton NHS. The question I have is, I think the parliaments are a bit out of order in my own mind. I wrote to Andrew Mitchell, the Conservative MP for Sutton Coldfield, to do with the way we are changing the Prime Minister. Because for the last 6 years, we've had about 4 Prime Ministers. So I don't know in terms of legislation. I know the Parliament makes the legislation which the court interprets and the police implement. How did they manage, for instance, when David Cameron proposed...
What's your question?
The question
and it must be pertinent to the Secretary of State's present responsibilities.
Yeah, because
otherwise.
I wrote to him saying that you're out of order because you're just looking at the press. The press does what they like and the Parliament follows them. And then that's why the economy is not stable, because we keep changing. David Cameron resigned.
I think, what's your question?
My question is, what the legislation governing the Parliament?
I think we've got the message. Gentleman there, thank you.
I'll keep it brief, sorry.
Name an organisation, please.
Well, Ethan, I'm as an individual at Aberdeen Uni. So I'm aware that there is legislation which means that police can't go on strike. Do you think that there's a case for expanding that to the legal profession on the argument of, dangerous criminals not being prosecuted and therefore obviously not immediately, but in an extreme situation, increasing the legislation or increasing the scope of it so that barristers wouldn't be allowed to strike as well under extreme circumstances? Thank you.
Do you want to take them all as a
Yes.
clutch of questions, a wide potpourri there to scratch
Yes.
a man with multiple portfolios?
Yes, no, I'll try and cover all of them. So, starting with Ethan, from a good Essex-based Southend West, where my grandparents were from and lived. Look, I'm looking at a whole range of things around how we ensure we can do this and deliver this in a way that is, as I say, for me, it's looking very, very carefully at what is the outcome we want to achieve and how do we best achieve that. That means being quite careful with what we do and not getting too caught up in what sounds good on first appraisal, but actually working through very methodically exactly what we want to achieve. So you'll have to bear with us a little bit longer, but making sure we can give that space to people is very key, which plays very well into the point about the Free Speech Union. I thought it was very disappointing actually to see that kind of people having to work through in that contractual way using contract law. There is a real issue sometimes when we see, and I know this from previous jobs when I was in the Home Office as well, the frustration around seeing certain things online that companies can be quite slow. They're getting much better now, but they have been historically very, very slow at dealing with. And it's hard to explain to somebody why something like the Free Speech Union is being taken off PayPal when you see things that are encouraging suicide and terrorism on wide social media from big multinational global companies. So I think we need to make sure that we're dealing with that as a priority rather than people's access to freedom of speech. In terms of your point about the Prime Minister, having been chairman of the Conservative Party, I know very well not to step on a chairman of the Conservative Party's toes, but I'm sure Jake won't mind me saying, well, the best thing we can do in the Conservative Party is make sure we stick with and back our leader. We've got to make sure that we are focused on that for delivering for people. And it's not an issue for Parliament, actually. It's the way the party rules work. And in terms of the strikes, look, I've always been personally, very much a personal view, I think, most of our emergency services do not and cannot strike. And I know from having gone through the Fire Brigade Union strike, some of our colleagues in the Armed Forces always found it slightly odd that they were having to come back from Afghanistan on leave, and while they're on leave, cover for firefighters who were going on strike over their pension age and things like that. So there is an issue there, but some parts of sectors can and some can't. I think the bar is quite different because some people don't often realise is all the barristers are actually self-employed. And even the Criminal Bar Association, that's often referred to as a union, isn't a union in that strictest sense because all of its members are self-employed. So we've been having discussions with the Criminal Bar Association. They will be putting this ballot to members next week. As I say, I hope they'll vote positively, but it is true we do need to ensure that we're not going through this kind of thing every 4 years. And that we've got a structure that means it can continue to deliver for people in a way that ensures that victims can see their access to justice is not being slowed down by this kind of action.
Thank you very much. Really, just tell the political cabinet, a fantastic audience here at Policy Exchange who've enjoyed your remarks, and that there's going to be a no less stellar panel now. I feel. Thank you.
Thank you. No, thank you all very much. Thank you.
Thank you, Professor Ekins. If you care to give your and thank you all for your patience.
So it's a pleasure to be able to speak on this important question. I want to start by making a general point and then turn to some more specific points about the Human Rights Act and the European Convention on Human Rights. And the general point is this, that in thinking about human rights law reform, I think we need to keep firmly in mind the distinction between human rights and human rights law. The UK, to my mind, has always, or at least for a long time, taken human rights seriously. But until recent years, we have not looked to the courts to protect our rights against Parliament. On the contrary, it was thought to be Parliament's responsibility to decide how the law should protect rights, and our rights were to be found in ordinary common law and legislation. And the question which should concern us really is how to protect human rights, not whether to protect them. And in particular, the question is what role courts, whether domestic or European, should have in this regard. So I think it's a mistake to confuse limiting the role of the court with breaching rights themselves. Well, let me turn to the Human Rights Act in particular. Conservative governments since 2010 have never been happy with the Act, but they've never managed to settle on a coherent plan to address its problems. The latest proposal, the Bill of Rights Bill, it did target some problems, but I think it was also less than clear about what rights it would protect, which risked introducing a new kind of problem. So for my part, I welcome the bill's withdrawal, provided that does not mean the end of reform. But what should be done instead? Well, I'm going to address this question in a new paper for Policy Exchange, which will be available soon. And I think that there is a strong case for simply repealing the Act, returning to the constitutional position as it stood before the Act was enacted and came into force. One would need careful consequential changes to minimise legal uncertainty, but in principle our Constitution would be much improved by simply removing the 1998 Act. It would then be for Parliament to decide freely what our law should be, without political litigation that distorts public deliberation and policy making. Now, one response to this proposal is to say that it's pointless in effect. Human rights law reform is impossible on the domestic level. Unless you leave the ECHR, the 1990 Act, and the 1998 Act, or something like it, is essential. I don't think that's right. Introducing the 1998 Act was a choice, and it's for the UK as an independent state to decide how best to give effect to its treaty obligations. Enacting the Human Rights Act made a very big difference to how UK judges think and act. Repealing it, or at least amending it, would help change judicial culture for the better. In addition, I think it bears noting that the 1998 Act has not exactly been stable. How the judges understand it, how they apply it, that has changed across the decades. And it should be for Parliament to decide what the Act requires or permits, not for the courts to decide that freely over time. Now, I note that the Supreme Court in some recent cases has, from my vantage point, corrected some past mistakes in decisions that I welcome. I think Parliament now, if it doesn't repeal the Act, should at least consolidate those judicial course corrections, give them statutory force, and it should go further still. In addition, when Parliament legislates to address some particular social problem, such as the Channel crossings perhaps, or legacy cases in Northern Ireland, it should consider disapplying the Human Rights Act so that enforcing the decision Parliament has made is not contingent on the outcome of litigation. Now, it's true that changes at the domestic level will not fix the problem at the European level. The problem, to be clear, from my point of view, is that the Strasbourg Court routinely misinterprets the ECHR, treats it as a living instrument rather than attempting to faithfully uphold the terms of the treaty. Leaving the ECHR, I think, would improve our constitution. It would not place us in company with Belarus and Russia, but rather with countries with similar constitutions, such as Australia and New Zealand. Of course, leaving the ECHR would be a big decision, major foreign policy implications, needs to be thought through carefully. There are technical objections that can be made, including by reference to devolution and the UK's trade and cooperation agreement with the EU. I think those technical problems are all surmountable, and I address them in this forthcoming paper I mentioned. But there is a good case for withdrawal, and I think it's a case that government and Parliament should reflect on and should adopt in principle, even if they decide that in the first instance it would be better to attempt treaty reform. But importantly, if we are to remain members of the Convention, at least for the time being, the UK should not accept that Parliament is obliged to change the law to comply with Strasbourg rulings that brazenly misinterpret the ECHR's terms. The prisoner voting saga shows what can be done in terms of working with the Committee of Ministers, and the UK should adopt that position in future. That's all I'll say for now. I look forward to questions and discussion. Thank you.
Brilliant. Thank you, Professor Ekins. Lord Faulks was a distinguished former Minister of State at the Ministry of Justice, and also served on the previous Human Rights Bill Review Commission in the early part of the last decade. Always welcome here. Look forward.
Thank you, Dean. I think the answer to the question from Mr. Costa, which the Lord Chancellor elegantly did not answer, is no. I don't think there will be a Bill of Rights resuscitated. That was the clear inference in what he said. I took no issue with his general statements of principle, which seemed to be impeccable in terms of the separation of powers, etc. But apart from identifying one or two discrete points, which after careful thought may appear in some legislation, I thought that it was pretty clear that we are not going to get a Bill of Rights. Now, for many people, that's a good thing because the Bill of Rights was not a perfect legislative vehicle. But we have to remember that the issue that the Conservatives have had with the Human Rights Act goes back a long way. It came in 1998 with no proper legislative scrutiny. There was no green paper, no white paper, and here was a major constitutional change. And apart from a policy document, which was published by the Labour Party, it simply became law. Very quickly, Blair had an enormous majority. Nobody quite knew what it would mean, and I speak with some experience because I was one of those who was sent around the country to address various groups of public authorities to say, what does all this mean? Many people said, well, it's not going to make much difference. It's just a check on all the rights that we already have defined in our common law or in various statutes. I have to say, when I read the Act, it seemed to me that it was handing over an enormous amount of power to judges, not the judges necessarily asked for it, and I thought it was opening Pandora's box in terms of legal uncertainty. When I said this on the first day of the Round Britain conference, the Blair government didn't like what I'd said, and I was pulled from the panel and given the graveyard slot of interesting cases from Strasbourg. But I remain of the view that this huge change was not properly thought through. But if you are going to bring in, and they cleverly called it the Human Rights Act, it is very difficult to do anything which appears to deprive people of human rights. We don't want to do that. But as Richard quite rightly says, the issue is whether parliamentary sovereignty counts for anything, or whether we should be subcontracting these things to judges. First of all, judges in this country have a particular view of certain socio-economic rights, for example, and ultimately to judges in the European Court of Human Rights in Strasbourg, who are a varied bunch. Some of them are excellent judges, some of them are not, and the jurisprudence is uneven, very difficult to follow, and has caused an enormous amount of litigation, a great deal of expense and uncertainty. Now, I'm afraid the Conservative Party hasn't done very well in responding to what was a problem. 2010, in coalition, clearly difficult, a commission on a Bill of Rights was set up. I joined in the second year after one of the members had found it impossible to agree anything. The members were never likely to agree very much, and although there was a majority in favour of a British Bill of Rights, including Lord Leicester, who'd been one of the enthusiasts for introducing the Human Rights Act, it never saw the light of day. When David Cameron won the election in 2016, I and Dominic Raab were given the opportunity of producing a consultation paper. It involved not leaving the European Convention, but recalibrating our rights to reflect some of the difficulties that have been encountered by litigants in the courts. But Brexit happened. So Theresa May had enough to do with Brexit without getting involved with the Council of Europe and possibly withdrawing from the Convention. And then, to bring things up to date, 2019, Constitution and Democracy Commission, an impossible task. So Boris Johnson's government decided to take it in two bite-sized chunks. One, the independent review of administrative law, which I chaired, and one, the looking into the possibility of amending the Human Rights Act. That particular committee decided things were more or less all right. Dominic Raab did not agree, produced the Bill of Rights, which contained, in my view, quite a lot of good ideas, but failed probably to grasp the nettle. Richard has grasped the nettle and will grasp the nettle in his published document, which will suggest withdrawing from the convention. Now, that will cause enormous problems internationally. There will be suggestions this is doing violence to the Good Friday Agreement. This is lowering our reputation in the world generally. Well, I wonder if this government has the appetite for that. However, if we do nothing, then we will not be able, as a government, to do some of the things that I think need to be done. Judges will still be able to exercise their own version of, for example, our immigration policy, and they will still be able to no doubt thinking they are complying with Strasbourg, create law in a way which, in my view, doesn't always reflect the balance between rights and responsibilities. So I fear, as I said, the answer is no, and I'm sure we're going to get one or two bits and pieces, but that's all we are going to get. Thank you.
Thank you. Simon Murray, again, always welcome on our platform.
Thank you very much. Is that working? Can you hear me over the crowd?
Yeah.
And I'm sorry that I'm not Nikki DaCosta. I do have some experience of human rights cases in courts. I do that day in, day out. And it's a system that is far from perfect. I don't need, I'm sure, to tell you all that. The question that we're looking at today is what is the future of human rights? And we've seen that the proposed Bill of Rights, whilst containing, as Edward rightly says, some good ideas, probably ducked the question ultimately. And that may be the reason why it's been withdrawn. The question then is what should be done over the next couple of years? And it seems to me that the question really arises on two levels. What we've got, as Edward has outlined, is a situation that when the Human Rights Act was introduced, the effect on the courts was that they were given a new and probably unwanted discretion to decide cases on an evaluation of rights claims and balancing competing rights. And as a result, what we've got is, as Edward puts it, a kind of contracting out of sovereignty from Parliament to the judges, and indeed ultimately to the judges in Strasbourg, who are a far from perfect tribunal. So the question arises particularly sharply in immigration cases. And we saw this in the run-up to the summer with the decision in Strasbourg to grant a Rule 39 interim measure precluding the removal of people who crossed the channel in small boats to Rwanda. And this followed a refusal of applications for interim relief in the domestic courts. So you can see, therefore, in stark relief, the problems created by the current implementation of human rights in the UK. So what's to be done? In reality, I suspect a sectoral approach is likely. And in relation to immigration, personally, I can see no other route than to provide for a system of notwithstanding clauses. Now, what I mean by that is that the operation of the 1998 Act, so the ability to implement and to ask a court to review whether your rights, your Strasbourg rights, have been breached in domestic courts, is simply not available to you in the immigration arena. That, it seems to me, would mean that any such claims would ultimately go to Strasbourg, but it would stop domestic litigation. Clearly, this is simply one option amongst many and something that will be explored, I'm sure, in due course. But all of these issues are certainly live, and it's something I think that the present government will have to grapple with in due course. As Richard rightly says, the question at the heart of all this is how to best protect human rights, certainly not whether to protect them. Thank you.
Thank you. Can I just exercise Chairman's privilege on one matter of significance? And you touched upon it in some ways, Lord Faulks, which is the whole question of what the particular impediments and barriers to entry for conservative or conservative-led ministries are in this respect. You know, what is, what are the barriers to entry in their own minds and in terms of the actual opposition within legal profession, the academy, and other stakeholders, so-called, in the equation?
I think there are a number of problems. Of
course, can people hear?
Can you hear or not? Yeah. The optics, of course, are not particularly good. If you have a government which is not, at the moment, particularly popular in terms of its economic policy, then to bring in legislation which is going to deprive people of their human rights is going to be a hard sell. So there is that practical problem. Whatever the reality is, and what the detail, in fact, is a proper recalibration, it's just going to be difficult to sell. But in terms of the difficulty with stakeholders, yes, there is a legal profession which is largely against any change. There are also problems in terms of getting bills through both houses of Parliament. I can foresee real problems in the House of Lords because the House of Lords, the Conservatives do not have a majority, and I think it would ultimately probably be a question of the Parliament Act. There's only about 2 years left of this particular government, depending on what other things might happen. I think they will have to start now, effectively. So when the Lord Chancellor talks about a leisurely look at what options are concerned, I don't think that's realistic. I think that they either get off the mark now and do something quickly, or essentially it's hopeless.
Brilliant, thank you. I don't know any of our other speakers. Professor Ekins. Please.
I agree with Edward that the Parliament Acts would probably have to be invoked, and so the clock is certainly ticking. And I think the balance of opinion in the legal profession is significant here, in that many lawyers, conservative lawyers, I think, have started to run together human rights and human rights law, like I've suggested, and start to think as though the Human Rights Act and our membership of the European Convention are pillars of protection for the rule of law and human rights. Now, you may infer from my accent that I wasn't always living in this country. I come from New Zealand, and in New Zealand, we are not members of the European Convention on Human Rights. We have a constitution similar in kind to the United Kingdom. And so the idea that if the United Kingdom were not a member of the European Convention, somehow we would have abdicated the rule of law and human rights, I am sceptical about it. I just simply don't think it makes sense. But the further you get away from 1998, I think the harder it is for people to recall the idea that you can have law and a constitutional government that takes people's rights seriously, that does not require policy to be determined by litigation. Now, of course, before 1998, you did have litigation in the European courts. It has increased, and it increases in terms of the types of question that get tackled over time. But the further we get away, I think, from the old constitution, maybe the harder that is to articulate, perhaps. And that's what needs to be recovered if there is to be reform.
Simon.
I would simply echo what Richard said. I think it's a matter that is going to require very careful handling.
That's fantastically diplomatic and that kind of thing. We almost thought you were the Lord Chancellor, actually, from that. I see other distinguished gentlemen there. I have to pretend impartiality and not know who you are and what your name and all. But if you could state your name and organisation as part of the show business of the proceedings.
Thank you, Dean. I'm Danny Kruger, MP for Devizes. Do you mind if I ask two questions quickly? One is to Simon. Could you clarify a little bit more about how you see the notwithstanding clauses operating if we were to introduce those into legislation to protect against appeals to the Human Rights Act? Because, as you say, in the case of Rwanda, it was Strasbourg judges who effectively overruled government policy. So, but you're suggesting, I think, notwithstanding the HRA, but staying in the convention. So, how would that help in the case of Rwanda? Maybe I misunderstood you, but that's my first question. Quickly jumping to Richard, could you just talk quickly about how you see the intersection between the Human Rights Act and the Equalities Act, and to what extent they might be argued to support each other positively? And I hear some concerns, particularly about the question raised earlier about religious freedom, that the HRA, which had some protections for religious freedom built in, actually helps to mitigate some of the bad effects of the public sector equality duty in the Equalities Act. And so do you think that repealing the HRA, as you suggest, and potentially withdrawing from the convention, could be done without also amending or even repealing the Equalities Act?
Sorry. Why don't you go ahead?
Sorry.
Expand at greater length than your last answer.
Yes, certainly. Thank you, Danny. I'm grateful you asked that question so I can amplify what I said. So in the Human Rights Act as it's currently drafted, Section 6 precludes a public authority from acting contrary to the Convention, and to do so is unlawful. And then in Section 7, a person can bring a claim in a UK court to prevent a public body from acting unlawfully or to seek damages for an unlawful act. And it's only those provisions in the Human Rights Act which allow a person to bring a claim under the Human Rights Act in the UK courts, because you can't bring a claim in the UK courts as an individual under an international treaty. It's simply not obviously, I'm aware that you're fully cognizant of that. But so if one switched off, to use the vernacular, those provisions in the Human Rights Act in a defined sphere in relation to immigration, there could be no domestic litigation arising on the back of the Human Rights Act. So that would reduce at a stroke the amount of litigation domestically in relation to immigration decisions. And it would be open to Parliament to decide what the law is, and the courts would then implement the law that Parliament has passed. It would then be open to an individual, if they wish, to challenge decisions made in relation to that law if they say they breach their human rights in the Strasbourg court. The Strasbourg court would then be able to decide whether or not, in their view, it was compatible. And you'd then have a situation where you could have a disagreement between the Strasbourg court, conceivably, and the UK government. But that would not mean that the policy would cease to have effect. So you'd have a situation, as we had with prisoner voting, where there is a disagreement between the member state and the Parliament. But these matters are generally resolved over a number of cases, but it does not prevent the policy having effect. Where we have the current regime, the courts are obliged to implement the Human Rights Act, and therefore policy measures can be prevented from having effect. So that would be the effect of what I suggest, maybe a solution. Sorry, and in relation to your Equalities Act point, no, I don't think it would there's a completely separate legislative regime. It wouldn't necessarily require any alteration at all.
Rich, can I just add quickly to Simon's excellent answer to your first question, which is that Simon and I and others tackled that question or explained how notwithstanding clauses would work in a paper published in February this year for Policy Exchange. So we've elaborated his excellent answer in print. And I agree that the Human Rights Act and the Equality Act are not strictly connected. I doubt myself that repeal of the Human Rights Act would somehow liberate the Equalities Act to have more of an effect on, say, religious freedom than it already does. I think the Equality Act is imprecise in some regards, which does give rise to problems. And there's a case to be made for making some targeted amendments to the Equality Act. But the way to amend it is to decide what you want the legal regime to be and go ahead and make it clear and build in the protections for religious freedom or parental freedom, whatever else it might be. Not, I think, to rely on litigation rounding off the edges of an otherwise imprecise act.
Edward, did you want to say anything?
No, I'm
okay.
fine, yeah.
Brilliant. Thank you. I'm just trying to get a flavour. The lady there, I think if you just say your name and all. Sorry, as the noise gets louder, if I can ask you to boom and project yourself even further for the sake
Don't worry,
of...
I stood against Andy Burnham before, so I'm quite able to articulate quite loud. My name is Laura Evans. So I'm not an academic, and I've learnt a lot from being here. But what I would ask you, or what I think Richard's got a perfect point, in fact, I think you've all got a great point, but you haven't articulated that anywhere near to Joe Blogg's public like me. So when I hear about Rwanda and your reasoning, it's quite clear where it goes back to. How are we, if you really want to make change, because you need to get the people to understand that it isn't being done by the government and it isn't constantly whoever happens to be taking on that role, as we saw with Priti Patel, and we're going to see with the next one, getting hammered for not doing what the people want, because actually the legislation is so complex and unclear. And if papers are great, but they are not making it into the Daily Mail and they're not making it into the Sun. So that's my question.
Richard. Well, I suppose I should say I'm an unusual academic in having published in the Daily Mail, but not every week, of course. And I think you must be right that the points in question, if we're right, or if we've got a case, have to be made broadly to the public as well as to the to policymakers and Westminster. And I think the narrative that is outlined and defended is vital. And if you fail to defend reform proposals as taking human rights seriously and defending the rule of law, and you concede somehow that they are inconsistent with it, then your policies will receive a very negative reaction, and understandably so. Articulating a more intelligent, frankly, narrative of the continuity with our traditional mode of government and with taking responsibility for how to solve controversial and difficult problems. And in making it clear, as the Lord Chancellor said, there will be disagreements about what should be done, and they will have to be fought out politely, well, maybe not politely, but by way of our democratic procedures, rather than by seeing who can persuade the marginal member of the Supreme Court, or in due course, Strasbourg. And so we have to make clearer that the decisions in question have not already been made. I mean, if the courts were applying, we had agreed that something should not be done, now we're proposing to do it, that would seem outrageous. But what's going on, I think, much more often is here's a difficult controversy, and here's some rather vague, abstract commitment that's now said to govern it. And rather, in fact, there's a decision that has to be made, and the people who should be making it are ones who can take responsibility for it and who can be removed if they make it badly.
Thank you.
Yeah, it's absolutely true that I think everybody who's looked at the Human Rights Act and possibly reforming it has said there ought to be a greater public education in what it all means, and that's quite true. I mean, why should the ordinary member of the public find it easy to distinguish between the European Court of Human Rights at Strasbourg and the CJEU sitting in Luxembourg? And I think a lot of people thought that when we had Brexit, that was the end of European judges, to quote, meddling in our affairs. But we have had a pretty stark illustration of the position with Rwanda. Now, whether you think the Rwanda policy is a good or a bad idea is beside the point. The question was whether it is lawful. And our courts decided that it was lawful. However, one judge, without hearing representations in Strasbourg, decided that it was not lawful. There is an appeal going on, or has been going on in various stages, and I think Simon is one of the barristers involved in it, determining whether it is lawful or unlawful by the laws of this country. It is odd, isn't it, that the government may decide on a policy which isn't popular, isn't a good idea, but it can't decide what is lawful. That's dependent on what a judge says in Strasbourg. So that's quite a clear illustration of the problems that people find difficult to grasp. But it is a real difficulty in trying to sell what is a sensible policy but doesn't have headline-grabbing aspects.
Yes, I think you've clearly identified a real issue in making it readily digestible. And I'm afraid I don't really have any good answers at the moment, but I'll think about it.
I see there's still quite a few people want to ask questions. I'm trying to get a flavour of who hasn't asked one yet. Gentleman there in front of the member for Devizes.
Hello, Jack Richardson, member in Rutland and Melton. You talked, Lord Faulks, about the Human Rights Act being poorly thought through, but I think it's been said that lots of others, like the reform of the post of Lord Chancellor and the Supreme Court, were as well. So as we embark on this process of reforming Human Rights Act, whatever reform it may take, what reforms do the panel think that ought to be made to the Lord Chancellor and Supreme Court as part of this process? Thank you.
Well, the position of the Lord Chancellor is actually something that's currently being considered by the Constitution Committee of the House of Lords, of which I am a member. We've been hearing evidence on this because, of course, it was changed really overnight by the Labour Party, who I think wanted to get rid of the then Lord Chancellor, Lord Irvine. It then proved to be impossible because the Lord Chancellor's role was so embedded in various pieces of legislation. Now, and this is without prejudice over to the individual holder, the question is, what is the Lord Chancellor? What does he or she have? What are their roles now, given that the position has so fundamentally altered? I mean, clearly, the guardian of the independence of the judiciary is something quite rightly identified by Brandon Lewis. Whether they have a slightly different role from any other cabinet minister, I think, is very important. I mean, in the old days, they used to sit in the highest court, the House of Lords Appellate Committee, so they were a living example of where we don't have a separation of powers, because they were the judicial, the executive part of the government, and also the legislative, actually making laws. And I think it may be time to look again at the position of the Lord Chancellor. What was the other thing we were going to look at? The Supreme Court. Yes, I wasn't, in fact, a great fan of the Supreme Court. I thought it was unnecessary. But I think in many ways it's bedded down quite well. There are moments when I think the Supreme Court has forgotten that it has no greater powers than its predecessor in title, as it were, had. I would have preferred, if we were going to have a Supreme Court, that it was the other side of the river in a great, beautiful architectural building, stressing the separation of powers. I think it will depend significantly, as does the American Supreme Court, on who is the president and what the general tenor of those judges are. I think the current president is of a slightly different, small c conservative lawyer than his predecessor. At the moment, I think the Supreme Court's working reasonably well.
I'll suggest one change in relation to the Lord Chancellor, which is that the Lord Chancellor used to have a much more robust role in relation to judicial appointments. And he or she, or he now, strictly has a role, but it has been extremely heavily circumscribed to the point where effectively you take the name that is given to you by the Commission. And we've proposed in a policy exchange paper the modest change, I think, which is requiring the Commission to come up with a short list of names amongst which the Lord Chancellor would have a real choice. I think that would be an improvement, because at the moment the position in relation to judicial appointments is too similar in kind to the state of affairs in which judges simply choose their new colleagues. It's not quite that, but it's too close to that for comfort.
Yes, the only comment I would have is that I agree with you. It was a very unfortunate set of reforms. And you may remember that it was followed by the short-lived, unloved Department of Constitutional Affairs, headed by the Lord Chancellor, who had very limited responsibilities. And then they hived prisons out of the Home Office and gave them to the Department for Constitutional Affairs and rebranded it as the Ministry of Justice, which always, to me, has a slightly Orwellian feel. And so there may well be a good basis of Edward's committee come to any concluded view for there to be a slight change, but I'm very certain that the Lord Chancellor should remain as the voice for the protection of the judiciary at cabinet level. And that is one of his most important functions, in my view.
Brilliant, thank you. I think one last question, gentleman there in that row. If you just wait till the microphone comes, your name and organisation.
Thank you very much. Nathan Evans, I suppose campaigner. I go out in all the red wall seats, and clearly the public do not understand this. It's interesting, it's fairly clear from what you've said. We should perhaps withdraw from the EHCR, but the actual messaging is going to be catastrophic. It's interesting, nobody would argue that New Zealand or Australia abuses human rights. So maybe on a messaging PR level, and clearly we need to get on with this if we're going to do it, maybe we argue that we should align with New Zealand or Australia and not the EU. Is there anything in that? Is there anything in legislation in New Zealand that we could try and mirror that would give the impression, for want of a better word, that we definitely want to honour human rights, which we clearly do?
Well, maybe I should speak to that. I mean, they are very similar constitutions, the constitution of the United Kingdom and that of New Zealand. So I think in one sense you should be pushing in an open door there. There is some similarity. So New Zealand does have a variation on the Human Rights Act, although it is much tamer as a constitutional instrument. So I think that argument does have to be made, namely that membership of the convention is not a requirement of civilization, and that one can have a constitution of the kind one had once upon a time, and that a similar country elsewhere has still. I'm not sure how much more I can say than that on that point now, but I think it does need to be stressed.
I suppose one illustration I occasionally give to people to explain why really the Human Rights Act wasn't particularly necessary. Take slavery. Now, quite rightly, slavery is the right not to be enslaved is part of the European Convention. But we abolished slavery quite a long time ago. And furthermore, we produced various pieces of legislation about modern slavery, which are far more nuanced. So let's not forget parliamentary sovereignty, whereby Parliament at the time responds to the particular challenges, as opposed to having these rights framed in very general terms and leaving it to judges to work out what his or her view of what the rights or wrong answers might be in a particular case.
I think in that time-honoured legal phrase, I'm going to say, I also agree.
Brilliant. Thank you, one, for all coming on a Sunday. Thank you for inaugurating our wonderful conference programme. thank you for braving the noise pollution, which I'm busy whilst on the platform making representations to the conference organisers, so let's hope that others will benefit from having blazed this trail. But above all, thank you. I think it's been made absolutely worthwhile through the noise and the maelstrom of this brilliant, wonderful unit of Judicial Power Project at Policy Exchange, headed by Professor Ekins, and stellar contributions also through the years from Lord Faulks and Simon Murray. Please join me in expressing our appreciation to them.